The Supreme Court just handed down a unanimous 9-0 decision that changes everything about how police use of force cases are handled in America. And if you've ever been pulled over, had a police encounter, or know someone who has, this ruling directly affects you right now. The case is Barnes versus Felix, decided on May 15th, 2025. And it just rewrote the rules in every single state across the country, all 50 states, every territory, every jurisdiction in America. Before we get into what this means for you, hit that subscribe button right now. Here's why this matters more than you think. Major Supreme Court decisions like this create ripple effects for months and years to come. Lower courts will be applying this ruling to thousands of cases, and 90% of people miss critical legal updates like this. I don't want you to be one of them. This is breaking down complex constitutional law into plain English so you can understand your rights and stay protected. So click subscribe now because you don't want to miss what comes next. Here's what happened and why all 9 justices agreed on something that almost never happens in high-stakes constitutional cases. Ashton Barnes was killed during a traffic stop in Texas over a toll violation. His mother, Janice Barnes, sued the police officer under the Fourth Amendment, arguing the shooting was unreasonable. The case went all the way to the Supreme Court, and what the justices said affects every American in every state when it comes to police encounters. The Supreme Court ruled 9-0 that courts must look at the totality of circumstances when evaluating whether a police officer's use of force was reasonable. Now that might sound simple, but let that sink in for a second. This ruling just obliterated how 4 major federal circuits were handling these cases. The 2nd, 4th, 5th, and 8th circuits had been using something called the moment of threat rule, and that rule just got destroyed by every single justice on the bench. Let me explain what the moment of threat rule was and why the Supreme Court unanimously rejected it. Under that rule, courts would only look at the precise moment an officer perceived a threat, basically the split second before they pulled the trigger. Everything that happened before that moment, ignored. All the decisions the officer made leading up to that moment, completely irrelevant. The tactical choices, the escalation, the alternatives available, none of it mattered under the old system. Justice Elena Kagan wrote the unanimous opinion, and she made it crystal clear. That approach violates the Fourth Amendment. The court said you cannot narrow the inquiry to just a single moment. You have to look at everything. What the officer did before, what choices they made, whether they escalated or de-escalated the situation, and whether their own actions created the danger they claimed to be responding to. This is absolutely massive, and here's why it matters to you personally. Think about any police encounter you've seen or experienced. Maybe you got pulled over for a broken taillight. Maybe someone called the cops on your neighbor. Maybe you witnessed a traffic stop that seemed to go wrong. In every one of those situations, what happens before the moment of crisis matters just as much as the moment itself. Under the old moment of threat rule that was used in those 4 circuits, if an officer made terrible decisions that escalated a situation from calm to dangerous, courts wouldn't consider those decisions. They'd only look at whether the officer felt threatened in that final second. But the Supreme Court just said that's not good enough, not even close. And all 9 justices agreed, which sends a massive signal to every judge in America. Let me give you a real-world example to explain exactly how this changes things. Imagine an officer pulls someone over for speeding. The driver is cooperative, sitting in their car with their hands visible on the steering wheel. But the officer immediately approaches with his weapon drawn, shouting conflicting commands. The driver, confused and scared, makes a sudden movement to comply with one of the commands. The officer shoots. Under the moment of threat rule, a court might say, well, in that split second, the officer saw a sudden movement and felt threatened, so the shooting was reasonable. Case dismissed. Officer protected. End of story. The family gets nothing. No justice, no accountability. But under the Supreme Court's new standard, or really the standard they just reinforced with this Bombshell ruling, courts have to ask completely different questions. Why did the officer approach with his weapon drawn for a routine traffic stop? Why did he shout conflicting commands? Did his own actions create the confusion and fear that led to the sudden movement? Did he have other options available before resorting to deadly force? Were there de-escalation tactics he could have used? Those questions now have to be asked and answered in every use of force case in America. All 50 states, every territory, every jurisdiction. This is not optional. This is constitutional law, and it applies everywhere. And if you're finding this helpful, imagine what you'll learn when I break down the 3 things you should never say to police during a traffic stop. Mistakes that thousands of people make every single day. Hit subscribe so you don't miss it, because those 3 mistakes could be the difference between walking away free and sitting in handcuffs. Now let's talk about what this means for the 4 circuits where the moment of threat rule was being used. That's the 2nd Circuit, covering New York, Connecticut, and Vermont. The 4th Circuit, covering Maryland, Virginia, West Virginia, North Carolina, and South Carolina. the Fifth Circuit covering Texas, Louisiana, and Mississippi, and the Eighth Circuit covering Arkansas, Iowa, Minnesota, Missouri, Nebraska, North Dakota, and South Dakota. If you live in any of those states, this decision matters even more to you. Why? Because cases that were dismissed under the old rule can now be reconsidered. Families who lost loved ones in police shootings and couldn't get their day in court because of the moment of threat rule now have a path forward. Lawyers who were told their cases were dead on arrival can refile or appeal. We're going to see a wave of litigation in these states. And I'm not talking about frivolous lawsuits. I'm talking about legitimate cases where families deserve answers and where officers' conduct needs to be scrutinized under the correct legal standard. This is about accountability, transparency, and making sure the Constitution actually means something when police use deadly force. But here's what the Supreme Court didn't say, and this is critically important. The court did not say that police officers can never use force. They didn't say that every shooting is automatically unreasonable, and they didn't eliminate qualified immunity, which is the legal doctrine that protects officers from civil liability in many situations. That protection still exists. What the court said is that when we're evaluating whether an officer's use of force was reasonable, we have to look at the whole picture. We have to consider whether the officer used de-escalation tactics. We have to ask whether the officer created the danger. We have to examine whether there were alternatives available. We have to look at the officer's training, experience, and tactical choices. Justice Kagan pointed to a previous case, Plumhoff versus Rickard from 2014, to explain this principle. In that case, a driver led police on a dangerous, high-speed chase for 5 minutes, driving recklessly and endangering everyone on the road. When officers finally shot and killed the driver to end the chase, the driver's family sued, arguing the shooting was unreasonable because at the moment of the shooting, the chase had ended. The Supreme Court rejected that argument completely. They said you can't just look at the final moment. You have to look at the entire 5 minutes of outrageously reckless behavior, the driver's repeated attempts to escape, and the ongoing danger he posed to innocent bystanders. In that context, the shooting was reasonable because the totality of circumstances justified it. So, the totality of circumstances standard works both ways. It protects officers when their use of force is justified by everything that happened leading up to it, but it also holds officers accountable when their own poor decisions escalated a situation unnecessarily. This is about fairness, accuracy, and getting the constitutional analysis right. Now, I want to address something that some people might be wondering. Why did this take so long? The Fourth Amendment has been around since 1791. The Supreme Court established the totality of circumstances test for police use of force back in 1989 in Graham versus Connor. So why were 4 federal circuits still using the moment of threat rule in 2025? The answer is that lower courts sometimes develop their own interpretations of Supreme Court precedent, and those interpretations can drift away from what the Supreme Court intended. The moment of threat rule started as a way to simplify complicated cases. It gave judges a clear framework. Just look at the moment before the shooting. Was there a threat? Yes or no? Simple, clean, easy to apply. But what seemed like a helpful simplification actually became a constitutional violation. It turned the Fourth Amendment's reasonableness requirement into a narrow, officer-friendly test that ignored critical context, and the Supreme Court just said no more. All 9 justices, liberal and conservative, appointed by Republican presidents and Democratic presidents, complete unanimity on a controversial issue. Now, let's talk about what this means for prosecutors and defense attorneys, because this affects criminal cases too. If you're facing charges related to resisting arrest or assault on an officer, this ruling could matter for your case. Here's why. Often, these charges arise from situations where police claim you were a threat and they had to use force to subdue you. But under the new standard, again, really the correct standard that's now being enforced nationwide, the question isn't just whether you made a threatening movement in one moment. The question is whether the officer's own actions created the situation where you appeared threatening. Defense attorneys can now argue, yes, my client pulled away from the officer, but only after the officer grabbed them without warning, without identifying himself as an officer, and without giving them a chance to comply with any commands. The officer's own actions created the situation that led to the alleged resistance. That argument has more weight now than ever before, and we're going to see it used in criminal cases across the country. This is going to change outcomes. This is going to change plea negotiations. This is going to change how prosecutors evaluate whether they even have a case worth pursuing. For prosecutors, this creates a new challenge. They can't just rely on an officer's testimony that I felt threatened in that moment. They have to be prepared to defend everything the officer did before that moment. They have to show that the officer's tactics were reasonable, that the officer didn't escalate unnecessarily, and that the use of force was the last resort, not the first option. And 73% of you watching right now aren't subscribed. Don't be part of that group. Join the thousands of people who get these updates first so you understand exactly how these legal changes affect your rights. Click subscribe and turn on notifications because the next ruling could drop any day. Now, here's something crucial that the Supreme Court emphasized in this decision. They said that officers often have to make split-second decisions in dangerous situations, and courts should not second-guess those decisions with the 20/20 vision of hindsight. That's important. The court is not asking officers to be perfect or to have superhuman judgment under pressure. But, and this is the key, the split-second decision is only one part of the analysis. If an officer had time to plan their approach, time to call for backup, time to use de-escalation tactics, and they chose not to do those things, then the split-second decision at the end might be unreasonable even if the officer genuinely felt threatened in that moment. Let me give you another example to drive this home. An officer responds to a call about a person having a mental health crisis. The person is in their own home, not threatening anyone else, but they're agitated and holding a kitchen knife. The officer has time. They have backup available. They could call a crisis intervention team. They could negotiate from outside. They could use less lethal options like a taser or pepper spray. But instead, the officer immediately enters the home, shouts commands, and when the person doesn't drop the knife fast enough, the officer shoots. Under the moment of threat rule, a court might say, in that moment, the person was holding a knife and didn't comply, so the shooting was reasonable. Next case. But under the totality of circumstances standard, the court asks completely different questions. Why did the officer enter immediately instead of containing the situation and calling for specialized help? Why didn't the officer try de-escalation? Did the officer create the immediate confrontation by their own tactical choices? Was there an immediate threat to anyone that required instant action? Those questions could change the outcome of the case entirely, and that's exactly what the Supreme Court wants. They want courts to look at the full context, not just a frozen moment in time that ignores everything that led to it. And here's something that's going to be controversial, but it needs to be said. This ruling is going to make some people uncomfortable. Police unions and some law enforcement leaders might argue that it second-guesses officers and makes their jobs harder. Some civil rights advocates might argue it doesn't go far enough, and that qualified immunity still protects too many officers. But here's what the Supreme Court did. They applied the Constitution as written. The Fourth Amendment protects against unreasonable seizures. A police shooting is a seizure. And reasonableness requires looking at all relevant circumstances, not just a frozen moment in time. All 9 justices agreed on this. That includes justices appointed by Republican presidents and Democratic presidents, justices who are considered conservative and justices who are considered liberal. When you get a 9-0 decision on a controversial issue like police use of force, it means the legal principle is clear and strong. It means this isn't about politics. It's about the Constitution. And it means every court in America has to follow it. Now, let me talk about what you should do if you're ever in a police encounter. First, understand that this ruling doesn't change your immediate responsibilities during a stop. You still need to comply with lawful commands. You still need to keep your hands visible. You still need to avoid sudden movements. Your safety in the moment depends on de-escalating the situation, not arguing about constitutional law on the side of the road. But what this ruling does is give you and your attorney more ammunition if you believe the officer acted unreasonably. If you're arrested, if force is used against you, if you're injured, document everything. Get witness contact information, get medical records if you're hurt, get a lawyer who understands this new standard and how it applies in your jurisdiction. And here's something important. Film the encounter if you can do so safely and legally. Your state might have laws about recording police, so know your rights before you start recording. But video evidence of what happened before the critical moment is now more valuable than ever under this totality of circumstances standard. That footage could show the officer's approach, their tactics, their commands, and whether they escalated or de-escalated. Let's talk about the practical impact in specific scenarios that affect millions of Americans. If you're a concealed carry permit holder and you get pulled over, this ruling matters for you. Why? Because the interaction between police and armed civilians is one of the highest risk scenarios that exists. Under the totality of circumstances standard, if an officer escalates a routine traffic stop into a deadly force situation because they learn you have a legal firearm, courts will now look at whether that escalation was reasonable. Did the officer give you clear instructions on how to handle the situation? Did they allow you to comply safely? Or did they create confusion and panic that led to the use of force? This doesn't mean you're automatically protected, but it means courts have to consider the full context of the encounter. They have to ask whether the officer's reaction to learning about your legal firearm was proportional and reasonable given all the circumstances. For business owners, especially those who call police for assistance, this ruling has implications too. If you call police to remove a trespasser or deal with a disturbance and the police use force, you could potentially be drawn into litigation. The totality of circumstances might include what information you gave to the dispatcher, whether you exaggerated the threat, and whether your actions contributed to how the situation unfolded. I'm not saying you shouldn't call police when you need help. I'm saying be accurate and truthful in your description of the situation, because that description affects how officers respond, and how they respond now gets scrutinized under this more comprehensive standard. For parents, especially parents of teenagers and young adults, this ruling is important for a different reason. Talk to your kids about police encounters. Teach them to comply with commands in the moment, but also teach them that if they believe an officer acted unreasonably, they have legal recourse after the fact. Don't resist in the moment, but don't think that resistance is your only option for asserting your rights. The court system is now required to look at the full picture, which means if an officer escalated unnecessarily, that matters. Your kids need to know this. They need to understand that compliance in the moment protects their physical safety, but documentation and legal action afterward protects their rights. Now, I want to address a common misconception about these cases. Some people think that if someone is breaking the law or disobeying commands, police can use any level of force they want. That's absolutely not true. The Fourth Amendment requires that force be proportional and reasonable in light of all the circumstances. So if someone is speeding, that's illegal. But it doesn't justify deadly force unless that speeding creates an immediate danger to others. If someone is shoplifting, that's illegal. But it doesn't justify a chokehold that kills them unless they're actively fighting and creating danger. The illegality of someone's actions is part of the totality of circumstances, but it's not a blank check for unlimited force. This decision is going to affect police training across the country. Departments are going to have to update their use of force policies to emphasize de-escalation, tactical patience, and situation management. The days of "I felt threatened, so I shot" being the end of the analysis are over. That's not enough anymore under this unanimous Supreme Court ruling. Good police departments were already training this way. They were already emphasizing de-escalation and viewing force as a last resort. For those departments, this ruling validates what they were already doing. But for departments that were relying on the moment of threat rule to shield questionable tactics, this is a wake-up call. They need to change their training, their policies, and their culture. One more thing I want to mention before we wrap up. This decision was written by Justice Kagan, with Justice Kavanaugh writing a concurrence joined by Justices Thomas, Alito, and Barrett. The fact that both opinions agreed on the core principle shows how unanimous this really is. The concurrence just added some additional thoughts about how the standard should be applied in specific contexts. When you have that level of agreement from justices across the ideological spectrum, it tells you this isn't a political decision. It's a constitutional one. It's about what the Fourth Amendment requires, not about liberal or conservative preferences on policing. So here's the bottom line. The Supreme Court just reinforced that the Fourth Amendment requires courts to look at everything when evaluating police use of force. You can't just freeze one moment and ignore everything that led to it. Officers' decisions before the critical moment matter. Their tactics matter. Their alternatives matter. And courts in all 50 states now have to apply this standard without exception. If you've been affected by police use of force, if you know someone who has, or if you just want to understand your rights, this decision is foundational. It's going to shape thousands of cases over the coming years. It's going to change how police are trained, how cases are prosecuted, and how courts evaluate these critical encounters. Hit that subscribe button right now because this is just the beginning. As courts apply Barnes versus Felix to new situations, I'll be covering every major development. I'll be breaking down what works in court, what doesn't, and what you need to know to protect yourself and your loved ones. Drop a comment below telling me what state you live in and whether you think this ruling will make a difference in your area. I read every comment, and your input helps me decide what to cover next. And remember, this is educational information, not legal advice. If you're involved in a situation with police, talk to a qualified attorney in your jurisdiction who understands civil rights law and how this Supreme Court decision applies to your specific circumstances. Every case is different, and you need someone who knows the laws where you live and can apply this ruling to your facts. Thanks for watching. Stay informed, know your rights, and I'll see you in the next video where we'll dive even deeper into how this plays out in real cases across America.